Senate Commerce is now in session. Senator Polozov, is that how I pronounce it?
Yes.
Representative Polozov. I was getting a promotion, field promotion. Anyway, it's good to see you this morning. How you doing?
Good morning. For the record, Yuri Polozov representing Merrimack 10.
Hold on a second. Everyone could be quiet so we can hear. Thank you. Start again, Representative. Go ahead.
Yuri Polozov representing Merrimack 10, Hooksett and Dunbarton. I'm here to introduce House Bill 173 relative to toilet facilities provided by restaurants. This bill is very short. It has one section and it repeals two RSAs, RSA 15540 and RSA 15541. Can't do any better, as was said in House Commerce Committee. Very short bill. So basically, it repeals unnecessary section of the law. As it stands, there are already current building code. So this portion of the law is either conflicts with current building code or provides unnecessary restrictions. And as I understand from testimonies in the House, DHHS prefers to refer to the current building code for structure requirements. So these sections are not needed. And FDIs through their food code and provides guidance to DHHS and building code enforcement. So again, this is not needed. So this bill removes the requirement for restaurants of food establishments that are capable of seating 25 or more or serve alcohol to provide separate toilet rooms for each sex. At the hearing at the House, it was established that the issue at hand was already addressed at the current adopted building code. And that's pretty much it. I will be happy to answer any questions, but I'm a little bit limited because I don't own a restaurant. I'm not in the building industry, but I will try my best.
Thank you.
Thank you. Maybe I missed something here. Got up too late or something. So you're saying restaurants, new restaurants, or would not have to have bathrooms, smaller restaurants? Is that what you're saying?
No. They still have to have enough bathrooms, and it established by current building code. So the issue is at hand is the type of restaurants, because, for example, there could be a single stall, single person bathroom that can be used both by males and females. And the current RSAs that we are trying to repeal, they're not adopting for this kind of bathrooms. And there are other types of bathrooms that are in compliance with DHHS preferences and current building code, but might conflict with the statutes.
Bingo, you got me in the front door. Thank you very much. Does anyone else have any questions? Senator
I might, yes. Thank you. So if you have 25 or more seats, as I understand it, you have to have a bathroom for each recognized gender, right? Fewer than 25, you just need a facility. So, and forgive me if you covered this, but so we're saying no restrooms required. Right?
No, restrooms are still required by the current building code. It was just very strict requirements, for example, that there should be separate toilet rooms for each sex. And there could be, for example, two bathrooms, but family bathrooms.
Right.
And family bathrooms could be used by by everyone, or it could be one person bathroom without specifying what sex, because if it's just for one person, it doesn't mean, but there still will be bathrooms. Obviously, businesses want to have bathrooms, but also the current code also provides it, but we just want to give, not have two different RSAs conflicting with the existing building code, and also potentially more unnecessary requirements for the businesses and for construction companies. But yeah, I can assure you that there will be bathrooms, and specialists who will testify after me, they can confirm it.
All right, thank you.
One more question from Senator Shanley. Thank you.
Thank you. Would I be then correct in assuming or understanding this, that the bill removes a portion of the RSA, which might in fact be duplicative or in conflict with the building codes that exist?
Yeah, yes, absolutely.
Thank you.
Thank you.
Very good. Thanks for your testimony.
Okay.
Bill Sherman. Mr. Sherman, good morning.
I'll apologize. I had trouble hearing the previous speaker, so if I duplicate things, please
That's
forgive
okay.
me. So I speak today as Chair of the State Building Code Review Board in favor of the bill as amended. Our charge, as you probably know, is to maintain the State Building Code for ratification by the legislature. So the State Building Code requires places where food is served to be provided with restrooms for new construction when some alterations occur, and if the food service occupancy is created by changing from another occupancy. The code requires the customers and employees to have access to these restrooms and sets specific distances as a limit. The first part of the existing statute basically requires restrooms and adds the requirement that restrooms be convenient, quote, which is a subjective term. The code uses feet. The next portion requires that restrooms be provided for each sex in smaller facilities and in all facilities serving alcohol. The building code has evolved on this issue as societal opinions have changed over time, the issue being separate sex restrooms. And to some extent, the 2018 model code currently in effect, and to a more complete extent, the 2021 model code now in the process of ratification, eliminates most requirements for separate sex facilities. I'd point you to what some people call the Dunkin' Donuts exception. 2 single-user restrooms posted, and you know where the line is forming. So the code has now gotten away from that and said single-user restrooms can just be all gender, no restrictions, use whatever's available. The newer code would actually permit the European style of, lavatories in the middle and closed stalls for use by anybody. I would note also that the current New Hampshire Building Code has an amendment to try and coordinate with this RSA, which is different, uses a different number than the code. And then the last section provides limited approval for the DHHS commissioner to waive these requirements, and that's in direct conflict with the state building code, as he has no authority to waive the state building code. So I'll conclude by noting that RSA 15540 was originally implemented in 1935, long before the implementation of modern codes and standards, and it's been modified over time. The provisions in this section are well covered by both the FDA Food Code, which is adopted by DHHS, and the State Building Code, and the authority to provide waivers, variances, modification of the requirements, or the use of alternative methods to the respective regulations have approval channels through other DHHS and building code enforcement provisions that are currently in effect. I'm happy to answer any questions, and thank you for permitting me to speak today.
Senator Richard.
Good morning. Thank you for your testimony. I just want to be clear that this would be new businesses going forward, that this would not cause any cost or problems for current restaurant owners.
The only place that would come into effect is under some levels of alteration. fairly significant ones, or what we call a change of occupancy.
Okay.
A mini mart suddenly decides to put in the tables and become a restaurant, that
Okay.
kind of thing.
Thank you.
Seeing no other questions, thank you very much.
Thank you.
Oh, I'm sorry, did you have something? No. Good. Thank you. Does anyone else wish to speak on HB 173? Seeing none, I close this hearing. We are just cruising. I'm getting longer if you're doing that to me again. Representative Muse, so you're bringing this bill. Good to see you today. 2 work days in a row, I'm seeing you. Must be lucky, my lucky days. Welcome to Senate Commerce.
Thank you much, Mr. Chair. My name is Representative David Muse. I represent Portsmouth, Newington, and Newcastle. HB 1047, the bill before you this morning, was one that we actually unanimously passed in the House, and we also and it was also put onto consent. In its original form, it was more of a traditional legislative study committee. I think one of the things, and Representative Thomas, who's actually on the committee that actually worked on the bill, one of the things that the committee decided was that rather than create another legislative study committee, it would be better to put people in charge of conducting this kind of an investigation who do this work and who are responsible for doing this sort of work. So the bill changed a little bit from the time it was originally introduced, but the purpose of it essentially remains the same. And I think what the bill really tries to do is it tries to address in a good faith way the task of really trying to better understand a problem that's hurting New Hampshire's reputation and that also is hurting a lot of our low income people. Specifically, a lot of the people who are eligible to apply for programs that the legislature has already agreed to fund that could make a genuine difference in their lives, for one reason or another, aren't taking advantage of those programs in the way that we'd like to see them take advantage of them. So some examples. In 2022, the legislature appropriated $35 million in budget surplus money to help New Hampshire households after a sudden spike in energy prices left us with some of the highest energy prices in the country. That assistance was targeted at an estimated 50,000 lower income households that made too much money to qualify for the federal low income heating assistance program. And in the end, only about 1,000 households wound up applying for that aid. And you remember what a huge controversy that was at the time. That's about a 2% participation rate at a time when energy prices were literally soaring in New Hampshire. So in some of the finger pointing that went on afterwards, there were some who blamed us in the legislature for targeting aid at lower income people rather than giving every household in the state, no matter what its level of income would have been, $100. And so, you know, one of the things that I asked myself when I saw that is, how did we reach a point where the lesson we're supposed to learn is that it's a bad idea to target low-income people during a crisis because we have a hard time managing it? From what I understand, there were issues with paper-based applications slowing down the process, but it also appears that there were just way too many people who never even knew about this program. Another example, our state was also recently in the news for terminating medical health coverage, Medicaid healthcare coverage for almost 20,000 children in 2023. Now, our 18% drop in New Hampshire was the third highest in the US, and it was brought about by the state's return to pre-pandemic eligibility rules. About a third of the New Hampshire kids were disenrolled because a parent or guardian didn't respond to multiple requests from the Department of Health and Human Services to have their child's eligibility reviewed. So despite what the department framed as a massive communication effort, over 6,500 kids still lost their health care coverage. Were their parents negligent? Was it a case where they didn't care? Or was it a case where they just simply didn't get the word? We also have ongoing issues with take-ups and under-enrollment under the Supplemental Nutrition Assistance Program, or SNAP. And this is an issue that actually, there was a bill in the Senate a year or so ago to try to address this, because about only half the people who are eligible for the program at the time enrolled. So what the Senate did, and the legislature as a whole, and then the governor signed it, SB 404 was passed, and that authorized actually the first SNAP outreach program since 2017. What I can't tell you is how successful that take-up has actually been, but what I can tell you is this is an issue that we run into over and over and over again here in New Hampshire. So what my bill would essentially do, as written now, is it would charge the Department of Health and Human Services in conjunction with the Department of Business and Economic Affairs to investigate the barriers that low-income residents face when it comes to receiving and addressing critical state outreach information. In particular, it would try to determine how widespread the use of electronic devices, such as computers and smartphones, are in this population, along with best practices used in other states to reach people who may lack electronic devices. So one of the things that's a little bit baked in here is the assumption that perhaps one of the issues might be that these folks don't have the same kind of electronic access that the rest of us do. One of the issues, why that continues to be a problem and why that is a problem, is actually sending people information electronically. If you have their email address or you have a way to text them or reach them, is one of the most cost-effective ways to do things. It's much more effective than printing something out and mailing it to 200,000 people. So I think part of what we're trying to do also is to get to a point where the Department of Business and Economic Affairs, through this outreach to the different agencies, can actually identify some best practices that could be implemented cross-agency. So, for instance, the Department of Health and Human Services may have knocked a communication program out of the park when it comes to a program like this, but somebody who's putting together a program to reach a similar audience in another agency may never even hear about it. So I think one of the things that we're trying to do is to basically do an investigation, see where we stand on some of these issues now, take a look at what other states are doing, take a look at the best practices that are being implemented in other states, and to try to bring some of those things back to New Hampshire so that when we do one of these programs, we actually can say it was a success. 2% for heating assistance. I mean, even 2 years later, just sort of sticks in my craw. And I'm sure that you folks feel the same way. And with that, I'll take any questions you have.
Thank you, Representative. I went to a lot of houses and told them about that, but it's not an effective way. You're right. Any questions? Seeing none, thank you for your testimony.
Thank you.
Wendy Thomas. Hi, Rep. Thomas. How you doing? Good morning.
I'm doing well, thank you. Pleased to be in front of you this morning. I am both a co-sponsor of this bill as well as I sit on Science, Tech, and Energy, and we heard this bill as it was introduced. We felt as a committee that this bill deserved more further investigation because we thought it was a good idea. And so we came up with an amendment that further identifies the goals of what is going to be done. We changed it from a study committee to a task. And we passed it unanimously, and it was on the House calendar. So for those of you that are familiar with Science, Tech, and Energy, for us to pass something unanimously means that it's a pretty good darn idea. One of the concerns I guess you're going to be hearing from HHS is their inclusion in this amendment. In Science and Tech, we included Health and Human Services because of the public health and safety aspect of computers and smartphones, those being disseminated health information, Amber Alerts, and something as mundane as weather alerts, which are becoming more and more common. I just heard from the representative from, not representative, but the person representing Health and Human Services, that they're going to object to being called into this. It's fine if they're removed. The reason, I wanted you to understand the reason, that they were included in the first place was because of the public health and safety aspect of this. But it's a good bill. It's going to resolve some issues. It's going to keep people safe and educated and informed. And I hope you pass it.
Thank you very much. Question? No? Thanks for your testimony. John Williams. David, you want to come up too? Are you alone today? Okay. I'll make sure they don't grill you too hard.
Chairman Gannon, members of the Senate Commerce Committee, for the record, I am John Williams. I'm the Legislative Director for the Department of Health and Human Services, and I do want to thank both the bill's prime sponsor, Representative Muse, and also the co-sponsor for their work on this initiative. It was a matter of timing, though, that we bring ourselves today before your committee. This is our first opportunity to have you hear the bill on the merits. The bill, as you heard, it was originally introduced, was a study committee, and it did actually the opposite of what you normally see, which is now turned into something more meaningful in terms of an investigation. It is true that the Department of Health and Human Services is involved with Medicaid, but also the Department of Insurance also is involved with also healthcare issues within the state. Our key goal here is just to relay that although we would be certainly a participant in that investigation, that the investigators would reach out to the department and get information from us, but we are not tasked as a state agency over information technology or information systems for all state agencies. So our suggestion respectfully would be to remove us from the bill. And I do have a draft amendment that if I could circulate this to the committee. And just drawing your attention when you do receive this document, which I'll wait a couple of seconds for that. Also, while waiting to getting the information provided to you, our department cares very much about performance metrics and outcomes. And so for the various bills that were very important and critical legislation, including the Supplemental Nutrition Assistance Program outreach, which was recognized and certainly was an excellent bill, that we do keep performance metrics and outcomes, and we do watch those things in terms of the success of those programs so that when we come back to the budget process, we can provide the legislature with that information. The same around the Medicaid enrollment, both for adults and children, that we were very thoughtful working through Director Henry Lippman on the unwind to identify families and get information out so there would be less gaps in coverage now that we came out of the pandemic and under the unwind. So those are very, very important. So as you see from the draft amendment, bringing your attention to line 2, we would just respectfully request striking Department of Health and Human Services in conjunction with the, and then the sentence would read the department for that sentence. Then also on line 3, striking the comma after the Department of Business and Economic Affairs. And then drawing your attention to line 6, striking after the word the department, commissioners, comma, or their designees from both departments, comma. So striking that phrase, starting with commissioner commissioner and to departments, and then striking the word jointly at the end of that sentence. The final change that we would bring your attention to requested would be on line 23, that the department, you would just strike S to making it singular for the department. That concludes my testimony. I do want to say thank you to the bill sponsor and prime sponsor or co-sponsor on the bill, because this is an important initiative. But the other issue for us is there's no appropriation. We were never received a fiscal note worksheet request by the LBA. So again, very thoughtful process, and shame on us, I guess, for not attending the work session, but we had no idea until we saw the bill cross over to the Senate that we were included in the support initiative. So thank you very much for your time, and I am available for questions.
Thank you. No, you're
Thank
safe.
you.
Thank you
Thank
for
you.
your testimony. Jake Eagleson. Is that you, Chase? Yeah. Oh, okay. You didn't check either way, so I was guessing you were. But thank you then. Does anyone else wish to testify on 1047? Seeing none, I'll close the hearing. When they had the free oil money,
Yeah.
I went to so many people. It was the best campaign. Thank you.
This is 182?
82.
82. Do I have an 82?
Yeah.
Seemed to have, 82. Unless it's right here. No. 173 is my first.
I have a copy, but you want to take a look at it?
Yeah, real quick.
Oh my God, there's a lot of speakers.
Do we want to speak?
I'm not surprised.
Your mic's.
Shall I start? Thank you, Chairman and Senator Gannon, and good morning. I'm Suzanne Vil. I am from Nashua Ward 3, which is also Hillsborough County District 6, and I am pleased to be before you. This is my first time in front of your committee. So I want to just introduce quickly the idea behind House Bill 82, and it's about the patient, basically. And then we have other testimony that will be very helpful, and I'll be happy to take your questions, but they may have better answers. What you have there in your handout is a copy of suggested changes on the top, and then you have a handout on the states in terms of what kind of employment and protections that they have for people in the therapeutic cannabis program in their states, as well as a copy of Supreme Court decision from New Hampshire on the Payne versus Ridaway case, where it was found that this gentleman was released from his job because of the fact that he was a patient in the program. So with that context in mind, Title 126 provides protection for the patients of the therapeutic cannabis program, and the case of Payne and Ridaway supports the program as it is written right now. The decision to interpret it, the nature of his firing on the basis of participating in the program has really led us to understand that this should also be in statute. The original bill, as written, helps to get that patient past that interview point where they may be asked if they're in the therapeutic cannabis program, which is at that point in the interview maybe one last chance to discriminate against the patient. So currently the participants are left with risk of termination, and many people are intimidated and don't apply for jobs because of their concern and because of the stigma that comes along with being a therapeutic cannabis patient. You might be afraid of whether you could get a job, and you might not be able to have that negotiation for your accommodations as you would if you were taking other medications. What brings people into treatment for therapeutic cannabis is that they often want to avoid costly surgeries and medications that you can take, which I'll name a couple, things like steroids, antidepressants that are targeted at pain, tranquilizers, sleeping pills. So we don't want to force somebody to give up their job because they have cancer and they need therapeutic cannabis in order to eat. And because they came down in the course of their work and needed to access this care, but now they're going to test positive for cannabis, and the law, as it's written, may be construed to protect, but is in fact not common knowledge among employers how to treat this. There are many companies who understand about Payne versus Ridaway. They're more progressive, and they understand that this court case really does settle the matter. So quickly, I will just go into presenting the bill in the committee. The committee took quite a bit of time. They were invested in the bill, and my understanding in conversations with the chair is that they really wanted to address this problem for the patients. I have behind me the ranking member of Resources, Recreation, and Development, the ranking member of Labor, and also the gentleman representative who authored the amendment that gives you the bill as amended. The bill as amended is extremely different from the original approach. And with that, I'll take any questions and hopefully move on to the next.
Thank you. Thank you for your testimony. I do have some questions, and again, I'm just seeing this amendment now, so I haven't gone through it, but I'm chair of transportation, and one of the big concerns is I deal a lot with the businesses who drive trucks, okay? And it's a very serious issue because there's so much liability involved. I do think that the bill is well intended, but I have some concerns about some of the vagueness of it. And for instance, since for instance, New Hampshire state employees, federal contracts, federal jobs, how would that be dealt with when it's not recognized as legal federally?
In the suggested amendments that I had, minor but important clarifications that should be on the top of your packet. We've made some changes at the first part, but at the second part, we are adding, it shall be deemed, and then first of all, I'll read all of the shall be. It shall be deemed that an employee being impaired by cannabis products while on duty is an undue hardship upon the employer. It shall be deemed an undue hardship upon an employer to require an employer to do any act that would put the employer in violation of federal law or cause it to lose a federal contract or funding. So that is our attempt to address some of those things. But there are other people here who can testify to further changes that they may want to make. Is that helpful?
Yeah, thank you. I'm basing what I read prior to today's meeting. And so when I get something out, I can't go through it. So I have to ask the questions based on what I have originally received. So thank you for your testimony.
Thank you.
Andreas, no? So I'm in the same boat. I haven't read any of this new stuff at all. So if I am an employer, and so if one of my workers came and said, here I am, and I really only need people who can climb ladders and work high. I don't really have any other positions for them, so I couldn't accommodate them in another job. Where would I be left? Would they have to go out on workers' compensation or something, or?
I think with any disability, you would make accommodations and you would do that on a case-by-case basis. And I'm sorry, but it just went out of my head what the first part of what you said as an employer. As an employer right now, should you, and I'm not talking about a federal contractor or CDL license that have other, but as it is right now, someone hires you, they decide that you need to do a urine test, you do the urine test. You could be taking opiates, you could be taking clonazepam, which is a long-acting type of Valium, benzodiazepine medication, and those would all be cleared if you have a prescription. You could be taking Percocet with Adderall with a Klonopin and come to work. And so what this is attempting to do is to give people the same protection as they would have with traditional methods so that they don't have to wind up with like a cascading drug list because they took steroids and it causes this problem, and then they took this and it causes that problem. So that's basically where the patient is coming from, and that's where I'm coming from. I'm coming from the patients.
Thank you very much. You are all set. Thank you. Rep. Seaworth. Good morning.
Good morning. Thank you, Mr. Chairman, and thank you to the committee for hearing this testimony. My name is Brian Seaworth. I represent the town of Pembroke. I am also the vice chair of the House Labor Committee. And finally, my name was on the amendment that became replaced the original bill. So I wanted to come and say a few words, particularly about how the amendment was drafted and be able to answer any questions on that. Obviously, like yourselves, there are a number of amendments and testimony that I haven't seen, so I don't really want to get into debating the details, but I want to be available as a resource. So obviously, and it was mentioned before, this was a bill from the prior year. We retained it in the House, and there were individual members had a number of issues with the language that we were having some difficulty resolving. The way this amendment went is, I'm glad it was already brought up, the Payne versus Ridaway Supreme Court decision. Some people had said to me, well, that makes it illegal to fire an employee with a medical marijuana card. if you actually look at that decision, and it's pretty short and it's actually easy to read, so I did, that's not quite what it says. What it says is that the issue is not the medical marijuana use, but the disability, and that's what needs to be accommodated. And in fact, the Supreme Court case didn't resolve it, it remanded it. It said the lower court looked at the wrong issues and you need to go and look at the right issues. So the solution that we came up with in House Labor was to look at the language in that court ruling and mirror the statute on what the court decided. And obviously, my name was on it. I think we did a good job. It also got the support of the majority of the committee, went on the consent calendar, and passed on a voice vote. So with that, I think I'll stop. I could probably go on, but if you have any questions, I'd be happy to concentrate on that.
You can amuse me with one. So I understand if you have a medical condition, you go to a doctor and they prescribe you a certain amount. I lost a leg, they gave me a certain percentage of gabagoblin. But I didn't self-prescribe it all. So my problem is, since the introduction of therapeutic marijuana, I've always seen it not treated like a medicine, which I want it to be treated. So you go in, you get a doctor to write you a note, you go to a cannabis dispensary, and you go in, and you sort of can tell the guy what you want. No, I don't want the 10% THC. I want something like 80%. I want it much stronger. So I don't see it treated like medicine. Can you just help me out and amuse me? Maybe it's just me, and get me through that.
Sure. And exactly those issues are why I think this bill came forward in the first place. And someone who follows me may talk about its redundancy relative to not just the Supreme Court ruling, because that relied on existing law. They just said, this is what's already in law and you have to follow it. The catch with medical marijuana is federal law. Because it's illegal at the federal level, it cannot be prescribed. So if one of your employees is prescribed opiates, that prescription could allow that to be removed from the drug test. It may also be, in terms of the language that we used here, an unreasonable accommodation to allow someone that has a certain level of opioids in their system can't do a part of the job until that medication is finished or reduced. So that's the intent of this bill, I think, is to say that because the federal law doesn't allow a prescription and we have this state version of a medical marijuana card that is prescribed to the doctor, by the doctor, we want to treat that in so much as possible on the same par as any other medication that would be prescribed to a patient in a similar circumstance.
So quick follow-up. So with the opioid dose, and you said you might wait till it dissipates to a certain potency or something. We're not doing that though with someone going in getting a 7% THC versus a 77%. So it could be in your system for a much longer time, yet we're not looking as an employer. I don't really know how much you're still affected by, as opposed to you taking 3% THC and 77% THC. I still don't, the doctor is leaving you off. I wish he was there at the therapeutic dispensary, and I know they can't be for the federal reasons. But if we could do that, then I would have no problem with it, because I would feel we're using it like a medicine, whereas I don't think we're using it like a medicine now, necessarily.
And I can't argue with any of that. What I would say is, somebody mentioned some of the vagueness in the language that the House passed. In part, that was intentional. If you look, I think it's in the ADA law, it was certainly in the Supreme Court ruling, that any of these determinations of reasonableness has to be done on a case-by-case basis in the facts of the case. And so this wouldn't prevent something from becoming a civil matter. And those kind of issues, I think, might be relevant depending on the employer, depending on the condition, depending on what the level of usage is. And I don't think we're able to solve that. The federal level has to solve it.
Thank you very much for your testimony. Any other questions? Seeing none, thank you.
Thank you very much.
Wendy Thomas, one more time. Okay, I was thinking that when I said that, it could be a third or fourth.
Hello again, for the record, and I don't think I introduced myself last time. It's Representative Wendy Thomas from the town of Merrimack. This is a bill that has come up before, and it's something that I absolutely support. First of all, I just want to make a correction. In the state of New Hampshire, we don't have a medical marijuana program. We have a therapeutic cannabis program. There is some discussion about the word marijuana being somewhat racist because it is actually the Mexican term for the plant, where cannabis is the Latin term. So we have a therapeutic cannabis program in New Hampshire. I used to work at a dispensary in Merrimack, and I've worked with many, many patients. There seems to be some confusion about therapeutic cannabis patients. And I am one. I am a patient. I've been a patient for about 6 years, and I don't think there's been a day in the last 6 years that I have not used therapeutic cannabis. The goal of patients in the therapeutic cannabis program is to allow them to control their symptoms so they can get back into life, get back to jobs, get back working. And I'm going to use we. We're tired of using opioids and being stuck on the couch and having symptoms. So we use cannabis to control our symptoms. The drug testing that we're talking about, cannabis can stay, or you can be tested positive for cannabis for 13 to 30 days after you ingest it, which means, and that the THC part of it wears off at about 6 hours. So every night for the last, as I said, 6 years, I take a nightly dose of 10 milligrams of a gummy. I don't smoke unless the pain is really, really bad. And so according to the drug testing, if I had a urine test right now, I would test positive for cannabis. That doesn't mean I'm under the influence of cannabis. It means that those chemicals are still in my body. I can work, I can come up here and testify, I can do everything, but I will test positive. So it's not fair to penalize someone who is using cannabis as medicine in a responsible manner. One of the questions you brought up was about dosage. So I'm a lightweight, even after 6 years on the program. 10 milligrams is my nighttime dose. It makes me sleepy. It makes me sleep through the night. If I took 10 milligrams during the day, I would be loopy. I would be inebriated. I've met many, many people, their dose is 100 milligrams at a time. That would floor me. That would absolutely floor me. But it's based on metabolism because it's a plant. It's a food that you digest. Just to compare it, my husband is an incredibly cheap date. One codeine tablet will put him on a couch for 3 days. I don't have that kind of metabolism. I need enough painkillers to put out a racehorse. That's just the way that we are. And that works the same way with cannabis. And you were talking about also the THC dosages, 7%, and I think you said 80% or something. I think I wrote down 80%. So for those of us that are lightweights or, that are even in the, actually it's for anyone, we can take a 7% dose and still function and everything. If I took an 80% THC dose, I would be knocked out. What do you do when you get knocked out? The next time you take it, you reduce your dose, just like we all learned how to drink hard liquor. The first time we drank it, we drank too much and we threw up and we didn't like that feeling. So the next time we had less and less and less until we found our dose. So equating inebriation to the percentage of THC is not the correct way to look at it. The correct way to looking at it is the dose that you take regardless of the THC. And also, this bill would not protect you if you're inebriated at work. I mean, if you're drunk at work, you would be called in and you would be let go. If you're inebriated and you sit there and say, "Ooh, the colors," or whatever, you're going to be called in, and you can be let go. You should not be inebriated at work. You talked about the driving under the influence. How do police officers know to pull over drunk drivers? They see cause, they see them crossing the line. It would be the same thing if you were under the effect of cannabis. You would be inebriated and you wouldn't be a careful driver. So there would be just reason to call you out, to pull you over. So this bill protects you when you are in a legal program in New Hampshire and you use the medication responsibly. So I'm happy to take any questions.
Thank you for your testimony. Seeing none, thank you. Aubrey Friedman. Morning, Mr. Friedman.
Good morning, Mr. Chairman, committee members, Aubrey Friedman, live in Bridgewater, private citizen. I speak in opposition to this bill. First of all, I totally support full decriminalization of marijuana or cannabis for recreational and therapeutic purposes for adults. That's my stance on it. However, just because you have a medical cannabis card or a therapeutic cannabis card, that doesn't give you special rights to a job that an employer may not want to give you. And they may have definite concerns, as was mentioned, the liability issue. I mean, this is a suing society, and they sue for every little thing. And of course, accidents happen, and right away there's lawsuits. So it's liability. I could see where an employer would want to be extra careful and drug test, and you just don't want problems. And also, I might add, it would be the insurance company. So virtually all businesses get insurance, and it might be the requirements of their insurance company to do the drug testing. And if you fail the drug test, that you got to get rid of the employee. So, or you might not be able to get insurance if you don't do the drug test, or it would be a lot more expensive, and that would be a hardship on the employer. So I don't think, on the other hand, I understand a lot of people are helped by cannabis for medical reasons, as been discussed just the previous speaker. So I think I don't think this bill solves the problem. I have a couple ideas for another bill, but I don't think this solves. One would be, as come up already, the federal requirements for federal civilian employees. You have to do the mandatory drug testing. Well, how about we in New Hampshire just nullify that federal law and just nullify it? So that would be the first thing to deal with that. Another idea is, I believe, and somebody could correct me if I'm wrong, it's considered discrimination if a company's policy, you test everybody or you test no one. That doesn't really make sense to me. You have employees who are driving, trucks or heavy equipment. That's more of a safety sensitive issue. Then you have people who work in the office, administrative. I was an accountant for most of my working life. And frankly, if I punch in a couple extra zeros on the computer because I'm a little out of it, which I didn't, that's not that serious. But somebody driving a truck or operating heavy equipment, we don't want to take a chance that, that's really more a safety issue. So I say maybe a law or a bill to allow a company to test certain employees depending on, within a company, of the job they do, whether it's more safety sensitive or not, and maybe not testing other employees, because we do want people who use the cannabis to be able to get a job. So, I certainly sympathize with that. But I think on the safety issue, I could see where the company would want to be more strict on that. So that would be a workaround, and I just think it comes at the wrong way on this bill, and that's why I oppose it.
Thank you, Mr. Friedman. Any questions? Seeing none, thank you.
Thank you.
Representative Sullivan. Sorry I didn't call you earlier. I missed that part. Good morning, Mr. Sullivan. How you doing?
Good morning. Thank you, Mr. Chairman. Thank you to the committee. My name is Brian Sullivan. I represent Sullivan County District 1, which is the fine town of Grantham. I'm also the ranking member on the House Labor Committee. And I just want to point out you've got the vice chair and the ranking member testifying on the same bill in the same direction, so that ought to be a good sign. And I did speak with Chairman Infantine this morning, and he would have been here as well if he weren't out of town. But I just wanted to make sure that I was expressing his views accurately, but Rep. Seaworth was here to take care of that. But I would like to point out a couple of things that I think are important. And those are guardrails that we frankly struggled with in the committee. We struggled with them because they're not in the bill. They're somewhere else. The guardrails, by and large, are in Title 10, Public Health, use of cannabis for therapeutic purposes. And that is the second page of the packet that you were handed. And once we delved into that statute, we got a lot more comfortable with not the use, but the dealing with therapeutic cannabis in the workplace. Partway down in number 2, it says nothing in this chapter shall exempt any person from arrest or prosecution for being under the influence of cannabis while operating a motor vehicle, commercial vehicle, boat, vessel, or any other vehicle propelled or drawn by power other than muscular power. So all of the concerns about motor vehicles are addressed there. And it also indicates under the influence. If you're not under the influence, you can have a therapeutic cannabis card and you can drive as long as you're not under the influence. People who use therapeutic cannabis and work are generally not under the influence at work. It goes on. It indicates that you cannot be under the influence in his or her place of employment without the written permission of the employer. So if the employer doesn't want you under the influence, they're not going to give you the written permission, and you cannot be under the influence then. Operating heavy machinery or handling dangerous instrumentality. Again, one of the concerns addressed. The use or possession of cannabis by a qualifying patient or designated caregiver for the purposes other than therapeutic use as permitted by this chapter. This does not permit recreational use of cannabis. It's only for the therapeutic purposes, and that's a different approach entirely. The smoking or vaporization of cannabis in any public place, including a public bus or other public vehicle, any public park, public beach, or public field, the possession of cannabis in any of the following: the building and grounds of any preschool, elementary, or secondary school which are located in an area designated as a drug-free zone. A place of employment without the written permission of the employer. You can't have cannabis at work without written permission. Any correctional facility, any public recreational center or youth center, any law enforcement facility. If you're a cop, you cannot be under the influence of cannabis in the law enforcement building. And I would add on that an earlier version of the bill was very specific about excluding law enforcement and fire personnel. And I can say the committee has no objection to including that. I think this amendment or the suggested adjustment to the bill addresses that. So I just wanted to, we went a long time before we really focused in on the statute. And the statute addresses a lot of the concerns that the committee was feeling. And once we saw that, We say, okay, all this stuff is addressed in statute. We don't have to worry about those pieces. We just have to worry about the reasonable accommodations. I want to point out again, the final sentence, the final new sentence in the suggested amendment that Representative Vil presented at the outset. It's the first page of your handout. The final sentence says, it shall be deemed an undue hardship upon an employer to require an employer to do any act that would put the employer in violation of a federal law or cause it to lose federal contractor funding. I think that addresses the law enforcement piece of it. If it doesn't, we're happy to have the Senate address that in any ways that you see appropriate. But the Supreme Court decision essentially has answered the question for us. We must accommodate people who have a therapeutic cannabis card. They decided for us. What this bill would do is it would put into statute what the Supreme Court has already determined. That way, no one else will ever again have to go to court to preserve the rights that they're already afforded under the current Supreme Court case. So this will simply save a lot of legal fees. With that, I'm happy to take any questions.
Thank you, Representative. None here off the hook. Thank you. Have a great day. Representative Heath Howard.
Thank you, Senator. My name is Representative Heath Howard. I serve the District of Stratford 4, which serves the towns of Stratford and Barrington. I come in support of this bill, HB 82, because I think it's a necessary protection for patients who are currently certified under the therapeutic cannabis program. Right now, I mean, when we're looking at protections for people who have other prescriptions, such as opiates, they have certain protections and lines for certain jobs, and there are certain jobs that they cannot hold, and people understand their limitations. I think that this language and the way that we're talking as amended will provide some flexibility for employers so that it doesn't put them in undue burden to continue employment. And I think that this just simply outlines the fact that if somebody is, like myself, where I am a member of the therapeutic cannabis program, and I, as somebody with a disability, would be looking for something a little bit more tame as a desk job, not necessarily something like a CDL, it would provide the necessary protections so that I couldn't be indiscriminately fired. And there are many people in the state just like me who are trying to avoid opiates specifically because of a lot of the problems that we've seen in our state around the opioid epidemic. And making sure that we can provide protections for people so that we're not necessarily forcing them into one bucket into going on opiates, because if they are instead looking at the therapeutic cannabis program and are worried that they won't have the protections there where they may lose their job, so they'd rather go with the potentially more addictive and deadly substance. I have a potential problem with that, and I would prefer that they have these necessary protections. That being said, I encourage you to support HB 82, and I'm open to any questions. Thank you.
Thank you, Representative Howard. Seeing none, you have a great day.
All right, thank you.
John Garrigan and Daniel Albert, if you'll come up together, that'd be great. Good morning. Good to see you again.
Oh, sorry. Red light or blue light, I can never remember. I'm Danielle Albert with the New Hampshire Department of Labor. I'm here with John Garrigan, also from the New Hampshire Department of Labor. The department would simply note we have reviewed the proposed amendment. I understand there's some new language. We've not seen it, but I believe we understand the content behind it based on today's discussion. We think we have an understanding of what the proposed language in the amendment is aiming to do. From a regulatory and technical standpoint, the part that the department would note or highlight is that through the proposed language, it is creating a requirement that employers provide reasonable accommodations for the employee who benefits from the presumption that the proposed language is creating. And again, from a technical regulatory standpoint, assessment of reasonable accommodations and their application is not a function that's currently typically performed by the Department of Labor. So there's not an infrastructure built into protective legislation or other areas of labor law for reference. And we thought that was just an important point or portion to highlight. Other than that, again, we understand the intent behind the proposed legislation, and we're happy to answer any questions that you may have.
Thank you for your testimony. Seeing none, have a good day. Dave Juve. Andrea, you're going with her? Are you here? Andrea Chatfield? Oh, you are there, okay.
It's sort of a buy one, get one.
That's, we did 2 in a row, so it's a good thing.
Good morning, Mr. Chair, members of the committee. For the record, my name is David Juve. I'm a Senior Vice President with the Business and Industry Association, and I'm here this morning with my colleague, Andrea Chatfield, who is an employment attorney with She and Finney, and she is also representing the HR State Council on this bill. I want to give a little bit of history quickly. This was a legislation that BIA was following last session. We did not have a position on it. I certainly understood the intent of the sponsors, and I felt that the Labor Committee understood employer concerns and were doing their best effort to try and address employer concerns. And so it came out of the House with no BIA involvement. And candidly, I looked at the House-passed version of the bill, and it seemed relatively benign to me. But as I often do, I sent it out to my group of BIA member advisors who specialize in employment law, and they identified a number of concerns that they had that I had not thought of. And very recently, yesterday, as a matter of fact, our board of directors recommended that BIA oppose this bill. I thought it would be helpful for Andrea, who is also the vice chair of BIA's HR committee, to be here to express what some of those concerns are. So with your permission, Mr. Chair, could I turn it over to Andrea?
Sounds good. She's been teaching me for years, so that's fine.
Maybe I can teach you some more too.
There you go.
Thank you for the opportunity to testify. The HR State Council has always, has supported and understands the the good intentions of this bill, but it is, in our opinion, it is inexpedient to legislate. And I'm going to summarize it, hopefully bullet for you, and then explain. First of all, existing law does offer the protections that this bill is seeking to provide already, and provides those protections under a much more established framework. And I'll go into that a little bit more. 2, and I'm glad there was somebody here from the Department of Labor. This is the wrong, it's the wrong statute. 275 is about, Department of Labor knows wages, they know workers' comp, they know safety. They are not equipped to understand the nuances of what's a reasonable accommodation, undue hardship, and that that's RSA 354A. Plus, I looked through RSA 275, and I did not see anywhere that there was a provision that would address violations of this law. So that's another issue. The language of HB 82 is actually, in our view, inconsistent with the language of RSA 126X, which is the therapeutic cannabis law. And it also, the other problem that we see that's a problem in this bill is that it requires employers to determine impairment, and there is no meaningful way to measure impairment other than the person being really impaired, and therefore you know that that's an undue hardship, but it also creates an incredible safety risk. And for employers with safety-sensitive positions who need to be proactive, not reactive, that's a problem. So that's my bullet points. I can give you, I guess, a little bit of an example on the existing law. The Payne versus Right-of-Way case is an important case, and it actually, what it does say is that the use of therapeutic cannabis can be a reasonable accommodation. And so therefore, that means that employers, when they're looking at these issues, should treat the use of cannabis, therapeutic cannabis, the same way it would treat or see any other medication being used. That's what the case is about. So I'll take the example, Senator Gannon, about you mentioned that you have a business and you have people who climb ladders. And if you had an employee who came to you and said, I've been diagnosed with PTSD and I've started taking therapeutic cannabis, I want to make sure that that's okay. That means he's asking for a reasonable accommodation that you allow him to use therapeutic cannabis. And that means under existing law that you would then engage in what we call the interactive process. And there's plenty of federal guidelines and regulations and case decisions both on state and federal level that guide employers as to what the interactive process is, where you say, okay, well, we'll give us some medical documentation about what you're taking and whether it would impair you on the job. These are the work hours you have. You would go through that interactive process with that person to determine, is it a reasonable accommodation, or would it create an undue hardship or direct threat to the safety of that employee? That's already in the law. And that's what the right-of-way v. Payne decision is telling employers you need to do. So already existing law creates this. As I mentioned, RSA 275, that's the wrong statute for this. It's the Human Rights Commission under 354A that looks at issues about what is reasonable accommodation, what is an undue hardship, and has the actual legal process that is much more conducive for employees because they can file a charge with the Human Rights Commission and go through that investigation process through them, as opposed to a claim under RSA 275. And again, there is no provision that I could find that would allow how you would address violations of that law. And then a couple of other things I wanted to mention, and it's mentioned in my written testimony, is that while, right now, the types of medical conditions that qualify a person to receive therapeutic cannabis are very serious medical conditions. More than likely, 99%, they're going to be already considered disabilities. And as a matter of fact, in the right-of-way case, the person had PTSD, and the court said that's the disability, and that's what you need to accommodate. What we're seeing is that the therapeutic cannabis law is being expanded. As a matter of fact, there's a few bills right now in front of the legislature to expand it. Expansions, and the expansions are reasonable, we understand them, that's fine. But in the future, if that expansion progresses, it may then cover conditions that are not necessarily disabilities that are entitled to reasonable accommodations. You need to take that into consideration. The other problem with it being under RSA 275 is it now applies to very small employers. The law against discrimination, 3454A, applies to employees with 6 or more employees and has certain other exemptions. RSA 275 doesn't have those exemptions. So an employer with 2 employees would now be required to reasonably accommodate somebody who is taking therapeutic cannabis, even though they don't have to accommodate any other disability. That is, again, inconsistent. And then the last thing I want to just mention is how it is inconsistent with our therapeutic cannabis statute already. Again, it's saying that impairment is an undue hardship. The RSA 126X, which is the therapeutic cannabis statute, talks about the fact that employers don't have to require anyone to, or don't have to allow people to either ingest therapeutic cannabis or be under the influence of it in the workplace. That is different from saying impairment. A person could argue, hey, I can take it in the workplace, I just don't have to be impaired. And again, impairment is something that is hard to measure until the person is actually impaired and is a threat, a safety threat. So those are the main points of my testimony. I'm happy to answer any questions. Oh, I do have one more point because it came up when you were talking before. You mentioned that people that apply for jobs are asked if they're taking therapeutic cannabis. That actually is against federal law to ask questions like that because it's likely to elicit information about a disability. And in the pre-employment stage, you can't do that. So that is something that should not be coming up in the pre-employment stage. And I've been doing this a long time. I work with lots of different employers, and the trend is for employers to say, you know what, we're not going to do pre-employment drug testing unless we absolutely have to. It's a safety-sensitive position or required by law. So a lot of employers are no longer doing pre-employment, and because of the therapeutic cannabis law, and because in many other states they've legalized the use of cannabis in general. So they're doing away with that, or if they are still doing pre-employment, a lot of times they're not including cannabis as one of the issues on the drug panel. So we see this as a solution to a problem that's not necessarily there. Thank you.
Thank you both. Seeing no questions, have a great day.
Okay. Did I teach anything?
You did. You always do. Elizabeth Sargent.
Good morning.
Morning.
Chairman Gannon, members of the committee. My name is Elizabeth Sargent. I'm here from Champaign Capital Group. We're a government relations firm here in Concord, New Hampshire, and I'm here today representing the New Hampshire Association of Chiefs of Police and the New Hampshire Sheriff's Association. So I would just don't have too much to add to what's already been said. I would just remind the committee that from a law enforcement perspective, marijuana is still on Schedule 1. So for law enforcement, that remains a concern. I have just handed out a proposed amendment. If you were to consider this legislation, we would respectfully ask that you would include this section shall not apply to employers, positions, or responsibilities where the use of cannabis is otherwise prohibited by statute, administrative rule, licensure, certification, or regulation for applicants and/or individuals during the course of employment. Furthermore, this section shall not apply in cases where this limitation conflicts with the employer's obligations under federal law or regulations, or to fulfill a state or federal contract, certification, or licensing obligation.
Thank you very much, Ms. Sargent. Seeing no questions, you're off the hook too.
Thank you.
Does anyone else wish to testify who didn't check off speaking? Might have wanted to speak. Seeing none, we'll close this hearing. Okay.
You can start now.
Okay. We'll probably everyone will leave me. I'll be back. Where are we? Oh, okay. I don't know what than I want. And actually, not a big handful though. 3, 5, 3, 4, 4. Just a little bit. What are you going to sell? Oh, okay. Okay. That's what they all say. Gotcha. Okay. That's all I can ask. Representative Reed, come on down. Okay, we're going to now hear HB 283. Representative Reed is going to introduce the bill.
Thank you, Mr. Chair, and thank you, honorable members. My name is Ellen Reed. I represent Rockinghamton, which is the towns of Newmarket and Newfields. Before you, HB 283, as amended out of the House, simply says that a landlord receiving a rental application fee would have to return any amount in excess of actual costs to the prospective tenant if they don't rent to that tenant within 30 days. The reason I put this bill in is because with our current housing crisis and vacancies at approximately 0.6%, there have been a number of landlords, not all landlords, but some kind of, predatory landlords that have taken the opportunity to take advantage of this housing crisis. And these application fees, because they have people desperate, clamoring for housing, have gone from usually around $25 to sometimes upwards of $250. They've also extended it to per person or per adult moving in rather than per application. They've also created something called holding fees, which never existed before, but sometimes these holding fees are in excess of $500. They've also started doing renewal fees, which I've never heard of before. Someone who's been in an apartment for years and years now is having to pay just to renew their lease. And all of this they're doing because people are desperate for housing. And in some cases, they don't even have to rent a unit. They may have a unit. They might not have a unit at all available. They may all be occupied, regardless of whether it's occupied or not. Some of these landlords, again, it's a minority of the landlord community, are raking in these application fees in excess of what they would even get for the rent for that unit. So if you have pretty pictures of a property online, you just pull in those application fees. People are desperate. And if you get 10 applicants, or if you're charging per adult, 5 couples applying at $250 per shot, that's $2,500 a month just in application fees. And the landlords are under no requirement whatsoever to actually run a credit check or a background check. In fact, it's been studied, and approximately 80% of all applications don't have any check whatsoever run on it. So even though the landlord takes that fee in, they don't have to do a single thing. They can just throw that application in the trash. They don't have any vacancies available, or they're not interested in renting something because they're getting all of those application fees, sometimes possibly in excess of what they would even get in rent. Excuse me. So, and what this means for tenants who are desperate for housing right now, and I don't have to stress to you how much we need people to be able to live in this state who can work, because we are under a graying of New Hampshire crisis, which is also, simply put, the housing crisis. And we can't expect people to deliver our mail and drive our propane trucks and make our lunches and clean our buildings and not make room for them. And so to have them have to, in some cases under this 0.6% vacancy, they may have to apply to dozens of places to find a place to live. And what that means is that they're going to have to put out $250 per place, times however many places that they have to apply to. So that means that just the search process can be prohibitively expensive for someone who is a normal worker in this state. I have just a couple real New Hampshire stories, recent stories. A woman in her early 60s was finally waited the many year process of getting a housing voucher. She was finally awarded a housing voucher because of a physical disability that she received that prevented her from working. And it also her disability resulted in the loss of her housing, making her housing inaccessible. For over a year, she was couch surfing with friends while she was looking and staying in hotels when she could afford to do so. She endured the recovery from her surgery for the disability on a couch at a friend's, in a friend's unfinished basement. Her only income is Social Security disability. She contacted an agency to request assistance with a holding fee. A holding fee, this new thing, it was $500 in this case, in addition to the application fee. And because of a restricted income, she didn't have the $500, but the agency was unable to help her with that $500 holding fee, meaning that she once again lost an opportunity, even with a voucher. Another real-world New Hampshire recent example is a single father who struggled with housing insecurity for a very long time. And he did finally get a place, came up with the $500 holding fee that another place was charging. And then because he wasn't able to move in at the date that they wanted him to move in, lost the place and the $500 after he had saved up in a situation of essentially homelessness over a long period of time. The original version of this bill put a cap. There's 17 states that put a cap, in some cases $0, a cap on application fees. In some of those states, $25 caps, $35 and $50. But in those states, landlords are expected to essentially eat the cost of doing business. And that cost, I really want to be clear, is about $10. It costs about $10 to run a background check in a few minutes, and same with a credit check. A lot of these landlords subscribe to services, so they don't pay per person, but at most you're talking around $10. This version, the Landlords Association, Kit Lord, and the Property Owners Association, Nick Norman, requested some changes to the language, so we came up with this that both of them ended up in the end supporting. So this just says that there's no cap. They just have to return anything in excess to actual costs within 30 days. I will just point out the last, starting with line 13, that letter F. It was specific, so all of 540 is landlord law, and it says all the stuff that landlords can't do. And the penalty under 540 actually refers to the Consumer Protection Act. The Consumer Protection Act says that the penalty is $1,000 or damages, whichever is greater. Under 540, it says every day that a landlord is in violation of a court order constitutes a separate violation. And so very late in the game, the landlords were worried that this was $1,000 a day penalty. It's not, it wasn't. Having said that, this exemption, so this would become the only thing that doesn't have an actual penalty under 540. Not ideal in my eyes, because I think it should have a disincentive. However, I think as it stands, it is a step in the right direction. And so I ask you for you to support this.
Thank you very much for your testimony. Go ahead, Senator Shen.
Thank you for your testimony. I just want to be clear because I had to step out. Because of the housing shortage and all of the people putting in multiple applications at high costs, they sometimes don't even hear back, but that money is gone. Is that correct?
Not only that is correct, Senator. Not only do they not hear back, the landlord is under no requirement, and in fact, 80% of the time doesn't run any check whatsoever. So that they take the $250 or whatever the fee is, and they throw the application in the garbage. They don't even don't have to look at the name. So that apparently happens about 80% of the time. And I want to reiterate, because we spoke with a number of landlords that have much more ethical practices than that, but this is a real thing that's happening amongst some landlords because they're taking advantage of the fact that we have this incredibly low vacancy and people are really desperate for homes.
So what this bill essentially would do is when a potential renter in good faith sends in their application and their deposit, if for whatever reason the landlord is not able to give them the apartment or whatever, they have to return a portion of it. Is that correct?
Correct. They would have to return any portion that is not documented as being spent on background check, credit check, and reasonable administrative costs. So they can spend all of that, and then whatever they didn't spend, they have to return within 30 days. The other little details in the bill is that the landlord does have to disclose what the fee is and what if they have any background or credit check that they're going to do ahead of time before accepting the money. And it also says that nothing in here will force a landlord to run those checks or prevent them from renting to someone who doesn't clear their particular check. So a landlord still has the option to rent to whomever they want. They just have to simply say, I'm going to run a background check, here's the fee, and then return anything they don't spend by the end of 30 days.
Thank you.
Thank you very much for your testimony. Seeing no other questions, have a great day. Julie Smiley. Unless you guys want to come up together, do another. Okay. I tried.
That's okay. Hi, my name's Julie Smiley. I live in Amherst, New Hampshire. I hope you don't mind if I read my testimony today. Public speaking isn't something that comes easy to me. But after 4 years working as a housing advocate with the Front Door Agency in Nashua, in the middle of the worst housing crisis in our history, it's given me motivation that I really needed to do something to help make a change and make things easier for people to find housing. And at the time, I thought that limiting rental application fees would be really low-hanging fruit. Many New England states at least limit fees and some disallow them entirely. And given the massive shortage of housing in New Hampshire, and the fact that the cards are very firmly stacked in favor of property owners right now, I really thought this bill was a no-brainer, and I was surprised at the resistance that we faced getting through in the House. But I'm incredibly relieved to be here today because I think this is going to have a major impact on people on the ground in New Hampshire. In the 4 years I worked as a housing advocate in Nashua, I received requests from countless people asking for assistance with rental application fees, many of whom were experiencing homelessness. And for many reasons, there are few, if any, agencies that can actually provide assistance with those rental application fees. And the duration of homelessness was most certainly extended for many families due to an ability to pay multiple application fees simply to apply for an apartment. As you've heard, application fees vary from $50 to $250. We're hearing of these really high holding fees. And given the housing crisis, most people, especially those without the greatest credit history, people with housing vouchers, people who are the most vulnerable in society, they have to apply for multiple apartments in order to find one that will actually rent to them. And people on low income were lucky if they could apply to 1 or 2 apartments a month. Most people do not have that kind of spare cash. And there's no guarantee that they will even lease up. Landlords are just receiving so many applications. And then once a family is actually homeless, the chance of them having that spare cash to pay for multiple application fees decreases immensely. And so limiting the rental application fees that can be charged is without doubt a major, it's going to reduce one of the barriers to housing. It's a very easy solution to a big problem that we have. In as far as securing the income for property owners and property managers, I have a document here produced by New Hampshire Housing that states we need 60,000 new units between now and 2030 to stabilize the housing market. It's really unlikely that we will generate those 60,000 units between now and then. So there's no real end in sight to the housing crisis. Property owners are absolutely assured of a good, stable income for the foreseeable future. They're at no risk of losing with this bill. Their costs will be covered. And as previously been discussed, property owners are making quite a nice profit from application fees, often receiving upwards of 50 applications per unit. And they can charge $75 to each applicant for just to submit an application. That's $3,750 right there, and they haven't had to do anything. And these fees we've heard are being charged for non-existent units. People that are desperate to find housing have paid application fees for apartments that don't even exist. There's nothing to stop me going out there this afternoon, copying pictures of an apartment, posting them on Craigslist and asking people to Venmo me $50 just to apply. And I had heard of many people while I was at the Front Door Agency that had unfortunately fallen prey to those kind of scams. And again, property owners will be protected. They receive a good income from their rentals. There is a cost of doing business, and that is generally more than met by rental income. But this bill was amended to ensure that property owners' costs of doing business were more than met. But it does prevent property owners from receiving multiple application fees for one apartment. It offers the bill offers transparency and protection for renters, particularly the most vulnerable. Again, I cannot stress it enough that it ensures property owners get to cover their costs of doing business. It's an easy fix to what's a clear, significant barrier to housing, and it will help prevent predatory practice. And I would ask that we reinstitute the penalty for non-compliance to give the bill some teeth. So I think that's all.
Testimony.
Any questions?
Seeing no questions, you have a great day.
Thank you.
Rich Alpreen. Oh, you have nothing written? You're just going to talk to us? This is awesome. Let's fill out a big thing out here.
Good morning. Good morning, still. My name is Rich Alpern. I've been a New Hampshire resident since 1983. The first rental that I had in New Hampshire was in Greenland. It was an entire farmhouse with a breezeway and a two-car garage for $500 a month. Bought a house in '86, and in the 2008 recession, I lost that house. That's when I had to look around for a place to rent. The place that I'm in now, still in Newmarket, is 650 square feet. And I have now been there 14 years, and I'm on my third landlord now. This third landlord is not a person that I can speak with. It's a conglomerate entity. And this conglomerate entity hired out a national organization to take care of the property. The mowing, the snow removal, and so forth. When I started renting in this building, I was paying $1,100 a month. This company came, and that included heat and hot water up until a year and a half ago when this conglomerate bought the building. I'm now up to $1,700 a month, and I'm paying for heat and hot water, which I never had to before. Because of medical reasons, I haven't been able to work in a year and a half. I've had my left knee replaced. I'm going to be looking at probably having the right knee done too, as you can see that I need this cane for that. So I started collecting Social Security, and after Medicare comes out and taxes come out, I have $2,400 a month in Social Security. My rent is $1,700 a month. So quickly do the math. What's left? Not much to pay my monthly car insurance, my groceries, my electricity, my heat and hot water. The thing that I'm here mostly for is this, what Ellen was talking about earlier, is these fees that these people, because they know you got nowhere to go, so they got this guillotine hanging over your head, and they throw all these fees at you that you can't do anything about because they know that you have no place to go. In 2022 midterms, Maggie Hassan came to Newmarket, and I got to ask her the question about the rental situation. She told me back in 2022 that the vacancy rate in New Hampshire was 0.05% vacancy rate. Anybody know what it is now? I don't, but she said that at that time, Maggie said that a healthy vacancy rate would be about 5%. So there's a huge difference there. And these conglomerate entities are snapping up these buildings, taking advantage of the people who know that they're trapped. There's no place they can go. I left Mass because I couldn't afford to buy a house and couldn't afford to rent in Mass. And I've been here for 40 years now in New Hampshire. And I'm going to be squeezed out and I can't go to Mass because it's more expensive in Mass. This new company now has a $99 renewal fee. I never had to pay a renewal fee for the 14 years prior to this. A renewal fee just for re-signing a lease for the next year. Like, why? Because they know they can get away with it. So I counted the word fee in my lease. 32 times the word fee shows up. If I don't wake up in the middle of the night when the plow's outside plowing the parking lot and they have to plow around my car and they have to come back, it's a $40 fee. Because I didn't wake up at 2 o'clock in the morning to move my car. Fee after fee after fee, and this $99 renewal fee, when I'm in this position that I'm in with Social Security and Medicare and just living expenses, you know, with what's been going on with how everything's so much more expensive, something's got to be done about not only these renewal fees, which is what Ellen was talking about, but I mean, these people are getting away with murder. Too many fees because they know you can't go anywhere. And if you complain, adios, goodbye. So anyway, that's all I have to say today.
Thank you. Seeing no questions, you have a good day. That will end 283. Okay, I didn't see a check, but for who? I'm sorry. Gotcha, okay. Am I okay, or did I didn't hear anything, did you? Okay. So we will reopen HB 283. Sorry I missed you, ma'am. Ms. Ward.
No problem. Thank you so much. Appreciate it. I'm Marie Swarble. I'm the CEO of the Front Door Agency, a position I've held for 26 years. And I can honestly say I've seen lots of ebb and flows in the market. And particularly, this has been the worst I have encountered or seen, particularly for a one-income household. One of the things that we do is, well, our mission is to provide critical services and support to families in crisis to help them transform and ultimately achieve sustainable independence. One way we do that is by providing security deposit assistance. And last year, actually since July of this past year, we have issued over $170,000 in security deposit assistance. In fiscal year 23, that exceeded over $200,000. One of the reasons that we've seen this 200% increase in the amount of security deposits is because of the holding fees and the application fees that people are also being subjected to. All their savings that they've had for a security deposit are now going to these other fees. We have seen actually brokerage fees are the latest trend right now. Brokerage fees as high as $800 are being charged. And these fees are non-refundable and are required upon move-in. We have one young mom approved for an apartment, but couldn't come up with the brokerage fee, plus a security deposit, plus first month's rent, plus actually what we're seeing too is people asking for last month's rent, which is not allowable. And she lost the apartment. And actually timing is apropos. As just yesterday, we saw we had an applicant who came in and they brought in this form that said, in order to apply, an applicant must pay first month's rent, last month's rent, security deposit, brokerage fee of half month's rent, and an application fee of $100 per adult in the household. Now think about that. With the average amount of rent at $2,000 for a 2-bedroom in Greater Nashua, that person would need $7,100 just to move into the apartment. That would be a burden for myself, never mind our low-income households. Yesterday, we also received an applicant requesting assistance for $810, which was for a holding fee, and $110 for an admin fee, and $13.55 for rental insurance, plus $920 for security deposit. So House Bill 283 would make a very small difference to many families we serve by allowing some transparency on fees and requiring the return of the fees if the apartment is not rented. We have seen multiple times, too many to count, of people applying to 7, 8 apartments at a time, and the apartments are already rented. We know firsthand that they've been rented because we help the person move into that apartment, and then we get a next applicant applying for that same apartment, and we know that it's already been rented, and they've lost out on $200. And that trend of asking for a background check fee or an application fee for each adult in the household is increasing. So people with multiple generations moving in, that those fees can way far exceed even the security deposit. So please know that not all landlords are incorporating these practices, but what concerns me is that we are seeing an increasing trend of these, particularly with our larger property management companies, which is really a surprise. And something that we've been trying to advocate directly with the property management companies, but as testimony prior, a lot of them are outside vendors now, outside of our state, and they don't want to negotiate. These are their rules. So also the Front Door Agency is a landlord, and ourselves, we own 69 units of housing, and we feel that doing these criminal background checks is a cost of doing business. We can decide who we want to rent to as a private landlord. And if we decide we want to do that, that's just our cost of doing business. And it should be standard across all the landlords. I also serve on the Greater Nashua Chamber of Commerce Board of Directors. And one of the things that we see is this is actually a barrier to helping the workforce. Again, our younger population, our college graduates coming, and they have to apply to housing. They don't have much credit already. So they can be, landlords are selective with them as well. And they're having to apply at multiple apartment complexes before that they get accepted for an apartment. So that is a huge outlay of funding for them as well. So House Bill 283 would be a great first step in helping more families and these recent college graduates in developing our workforce in our area. So I hope and urge you to pass this important bill. Thank you so much.
Thank you for your testimony. Seeing no questions, have a great day. Anyone else wish to testify? Gone on 283. One to go. Maybe there'll be nobody on there. I'll go through. Less people here. I think people have left them. Wendy Thomas. I know you're going to get right to the point and just hone right in.
I am going to do my best here.
Thank you, ma'am.
Wendy Thomas, I represent the town of Merrimack. I have worked in the PFAS arena for the last 8 years. In 2018, a bill that was similar to this was introduced by Representative Kathy Stack, also from Merrimack. Real estate agents currently must notify buyers of the possibility of lead, arsenic, and radon in their water. This bill asks them to now include the possibility and the notification of PFAS chemicals. Why? Recently, the IARC, which is a subcommittee of the WHO, has declared that PFOA chemicals are carcinogenic. PFAS are likely carcinogenic, and with a little more investigation, I'm quite certain they will also be designated as carcinogenic. That makes this a protection bill. I'm going to give you a snapshot of what it's like to live in a town that is contaminated with PFAS chemicals. In my neighborhood, I live in an older neighborhood that abuts an even older neighborhood. There are 4 houses on my street that have private wells. All of our private wells are contaminated with PFAS chemicals. In house number 1, the dad has died of kidney cancer. In house number 2, the dad and the adult son have died of colon cancer. In house number 3, the dad is currently dying of stage 4 prostate cancer. House number 4 is mine. In 2019, my husband had a quadruple bypass at the age of 55. And in 2022, I was diagnosed with breast cancer. All of these conditions are related to chronic PFAS exposure. And I'm going to give you just a little idea of the cost, the monetary cost of living with PFAS. We put in a whole house filtration system in 2016. At the time, it was $3,000 with $1,000 to install it. We also put in a reverse osmosis filtration system. It cost $1,000 and $900 to install it. To maintain these filtration systems, it costs us $500 a year. We are one of 700 families that exist on bottled water because we cannot trust that our whole house filtration system is getting all of the chemicals that are being put out by Saint-Gobain. So we're on bottled water that's supplied by Saint-Gobain. For the last 4 years, every drop of water that we drink, every drop of water that we cook with comes from plastic. Which means that we have to go to the recycling center at least once a week. The health costs, we have cancer in our town. We've got costs for treatment. We've got costs for surgery. We have costs for monitoring. We have costs for prescriptions. We have costs for physical therapy. Let's talk about small animal health. I recently put down my 4th small dog to cancer. So those of us with animals, we have veterinarian costs and we have euthanasia costs. We can talk about the emotional impact, the sleepless nights, worrying about your kids. I have 6 children that grew up on this water. They all have health issues. And as we know, or as we have learned, PFAS is excreted from women through breast milk. And I've breastfed all of my kids thinking that I was doing them a favor. And in actuality, I ended up poisoning them. The town costs to live in a town with PFAS. We've paid to filter our public school water. The town voted on a town warrant to pay $14 million to pay for town filtration. We have increased school costs for our special ed kids because chronic PFAS exposure while a woman is pregnant means a lower birth weight and a higher incidence of learning disabilities, with autism being at the top of that list. We pay the price for having PFAS in our water and our environment. Imagine moving into a new home and having no idea that this potential harm is in the water or in your environment. Not notifying potential buyers of PFAS exposure is immoral, unethical, and in my opinion, criminal. New Hampshire residents need this protection, and that's why this bill is before you. Thank you. I'll take any questions.
Thank you, Representative Thomas. I'm sure I speak for all of us. Our sympathies go out to everything you've faced and are still facing. Go ahead, Senator Shardy.
Thank you.
I'm sorry.
I'm sorry, the chair is.
I'm sorry. I saw the chair, didn't see it.
As I read the notification that you propose in this bill, you're not requiring that someone, in order to sell, test their water. You're advising that a buyer. So you're not, I guess, I'm trying to figure out, you're not adding a cost to the purchase.
No, there's no cost
But
at
it's
all.
an advisory to the buyer that the potential exists so that they can, should they choose, test the water prior to purchase.
Correct.
Okay,
Correct.
thank you.
Very good, thank you. Yes, Senator Shardy.
That was similar to what I was going to ask, because we now have where you do test for radon and other things. So therein lies the difference here. And again, I'm sorry for everything you've gone through. In Bedford, we have people on bottled water for 5 years. I think you know I'm on the PFAS Commission and trying to fight these battles together collectively. So thank you for bringing the bill forward.
Thank you.
Thank you for your testimony again. Bob Quinn.
Hello?
Still morning for another 2 minutes, Mr. Quinn.
Good morning, and I will be done before the afternoon, I promise.
Okay, thank you.
My name is Bob Quinn. I am the CEO of the New Hampshire Association of Realtors. And we worked with the House members to craft the language that you see before you in the amendment. We are supportive of the bill. You'll see as I'm handing out the purchase and sale agreement from the New Hampshire Association of Realtors, this language would go into section 12 on page 2. You see current language we're dealing with, as was Representative Thomas mentioned, radon, arsenic, and lead. You'll also just notice that on the next section 13, there's a requirement that the buyer has to acknowledge receipt of the property disclosure form from the seller. That disclosure form also has information regarding water quality. So if a seller has actual knowledge of a water test or contamination with PFAS, they would be required to disclose that in the transaction. And then on section 14, you'll notice the inspections. So the buyers, again, must sign off on potentially making the sale or transfer of the property contingent upon a water quality test, of which certainly PFAS could be included. So with that, I think there are a couple of different areas where a buyer, there are tripwires that this information that's being added on section 12 is really designed to elicit a conversation between the buyer, the seller, and their agents in terms of moving forward. I will also just mention that you will be seeing in the next couple of weeks another bill coming to you that would add something else to 477A on flood insurance and flood mapping. We also worked with House members on that language. The key thing we always just like to remind legislators is if you put a lot of language into 477A, it diminishes the likelihood someone's actually going to read it. It really is designed to spark that conversation and discussion, not to provide every bit of information that a buyer might need or want. So with that, I'm happy to take any questions.
Thank you very much, Mr. Quinn. Seeing no questions, you have a good day.
Thank you.
Ellen Reed. She's gone. She was left. Sorry, Ellen. And last would be Rosemary Remy.
Thank you very much, Senator. For the record, my name is Rosemary Rung. I represent Hillsborough 12, which is a town of Merrimack. And I'm speaking today as a member of the HB 737 Commission. It was formed by statute in 2019 to study the health and environmental impacts of PFAS contamination in southern New Hampshire, primarily Merrimack, Bedford, and Litchfield. This past year, last year we passed legislation to add Londonderry to that commission representatives because what we've learned is that, and we've known this all along, is groundwater flows. And the contamination that's been concentrated in Merrimack has spread to other communities. I hope that we're not introducing a bill next year or the year after to add Derry and other communities. I mean, Manchester's been affected, Hudson's been affected. Groundwater flows and wells get contaminated. As of now, there's about 4,000 residences, properties that have been identified for sampling. And I think about 2,500 of those had to be supplied with bottled water or alternate water sources because of the contamination. Even since January, 100 properties have been added to that list that's being supplied with bottled water. Now, properties within the outer boundary of the consent decree, which was an agreement between Saint-Gobain and the New Hampshire Department of Environmental Services. The management of sampling and alternative water sources is prescribed by that consent decree. But where we've now seen a lot of properties outside that outer boundary are being affected, those residences don't have the notification, the formal communication with their towns through the commission, their representatives, to be able to understand if they're at risk. And so I strongly support this bill because, first of all, PFAS it doesn't take much to provide a health hazard. In fact, there was an announcement last year, I believe it was last year, that there really is no, it's in the parts per quadrillion levels is the health advisory for PFOA. And it's odorless, it's tasteless, it's colorless. So people coming into New Hampshire that are buying a property, particularly in an area that could potentially have this groundwater flow affecting it, they need some notice at the time of purchase that their water may be impacted. 48% of properties in New Hampshire are served by private wells, so that's a big chunk. And I don't want you to think it's just a Southern New Hampshire problem. The USGS, in partnership with DES, had conducted a soil survey, which was completed last year. And they took the state of New Hampshire and they divided it into 100 grids, a grid of 100 properties. And it was pretty much consistent throughout the state. I know there was areas in the White Mountains they didn't get into, but every single soil sample tested positive for PFAS. So I think any property owner in New Hampshire that or somebody coming in to purchase property needs to be aware that their well may have a presence of PFAS, and having this notification would at least alert them that testing may be required for that. So with that, I would be happy to answer any questions.
Seeing none, thank you for your
Okay,
testimony.
thank you.
Does anyone else? Come on up. Brandon? Okay. You didn't check off, but we're fine. The speaking part.
All right, I'll be very quick.
Next time we'll get you.
All right,
Thank you.
Thank you. I'm Brandon Kernan. I'm the administrator of the Drinking Water and Groundwater Bureau at the Department of Environmental Services. We support House Bill 398. It was worked on by a pretty diverse group of stakeholders who gained consensus on the bill that's before you. Just want to reiterate that it's important that home buyers be notified about PFAS. We've sampled about 12,000 private wells in New Hampshire, mostly in southern New Hampshire, where our population center has been contaminated with multiple air emission sites. And about 27% of those private wells exceed New Hampshire's drinking water standards for PFAS, and about 57% will exceed the draft EPA standard if they actually adopted the next 1 to 3 weeks, which we expect. So we think it's a very good idea, and happy to answer any questions. Thank you.
Thank you very much. Seeing none, have a great day. Anyone else have missed wish to testify? Seeing none, the hearing is closed.